If you were arrested for domestic violence as a felony, then this video is for you because I'm going to be talking about the 3 worst things that can happen during your case about halfway through at a preliminary hearing. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you from start to finish everything you need to know to represent yourself at your restraining order hearing and win. So if that is something that you're interested in, make sure you get your free first class in the course via the link down below. Okay, so let's jump right in. The 3 worst things that can happen at your preliminary hearing. Number 3 will probably shock you, and it might be the most important one to keep in mind as you go through your domestic violence case and you are making decisions on what to do. For felony cases in the state of California, about halfway through the case, there will be what is called a preliminary hearing. Another term for it is probable cause hearing. And it is where the prosecution has to show that they have probable cause that a crime was committed and that you committed it in your case. What the prosecution has to present is not beyond a reasonable doubt. That's what they would need to convict you in front of a jury at trial. Instead, it is just probable cause, the same standard to arrest you. Right, so that's a very low standard, as you have probably seen. But now it is in front of a judge. You get to have a lawyer ask questions of whatever witnesses the prosecution puts on. So now that we have some background information, let's get into those 3 worst things that can happen. Number 1, new charges or allegations are added. Okay, so during a preliminary hearing, the prosecution is going to put on witnesses. Maybe it's the alleged victim, maybe it is just police officers, and I'll get more into that in number 3. But let's say that when the police officer or the alleged victim is describing the injuries that occurred, supposedly, to the alleged victim, if they're worse than what the prosecution initially realized or noticed. For example, maybe the victim had to get stitches and the prosecution didn't realize that, weren't paying attention to that, didn't know that until that day. Stitches, a concussion, really bad bruising, if there was any sort of broken bone or anything that's being attributed to this incident. Maybe it's just that the defendant pushed the alleged victim and the defendant says, I did so, but it was self-defense. The alleged victim trips and breaks a pinky toe. Okay, that could arguably be great bodily injury. And so there can now be this new allegation of great bodily injury added to your standard PC 273.5A, which is corporal injury to a spouse or cohabitant. Felony domestic violence, basically, which is a wobbler and can be reduced to a misdemeanor, but it makes it much more serious. It makes the penalties to you potentially higher. There could also be some sort of allegation that maybe the alleged victim, when they're up on the stand telling a story, maybe this didn't make it into the police report for any number of reasons, describes that they were trying to call 911 and you grabbed the phone from their hand and stopped them from doing that. Okay, well now you were dissuading a witness. So that makes the case more serious. The case has actually gotten worse because of that. And these are important things to keep in mind and things to talk about with your attorney before the preliminary hearing. So if you tell the attorney exactly what happened, I mean, the victim could go up in the stand and lie, but there may be things like this that you know about that maybe the prosecution hasn't noticed, and your attorney should be clued into before and you should be prepared for. Number 2 is that your bond gets increased. Okay, so you bond out for PC 273.5A. Typically your bond is $50,000. You pay a bail bondsman $5,000, and now you've been at court. By the time you get to your preliminary hearing, like I said, halfway through the case or so, you've been to court many times, right? And you've been showing up, you've been doing everything you're supposed to do. Well, if there are new charges added, or frankly, if the judge just gets mad hearing about everything that went on, which is rare for domestic violence cases, but if that happens, your bond can be increased. Now, if your bond is increased, if the amount of bail that you were supposed to pay or post gets increased to, let's say, $100,000, and you've only posted $50,000, well, now unless you, through a bail bondsman or otherwise, actually post that $50,000, you will go into custody. And it's rare, but it does happen. The DA can add a new charge and then ask that the bail be increased based on that. The judge can find that there's a change in circumstance and increase the bail on their own. But either way, this is something you should be prepared for, especially after you talk to your attorney if it seems like you are sort of undercharged, like there are more things that they could have charged you with. Not that you necessarily did, but based on the alleged victim's story, that maybe they sort of missed, and that might show up at the preliminary hearing. Number 3. Okay, so this is the one that always shocks everyone. And that is, what if the victim doesn't show up, right? I hear that question all the time. Sometimes it is from the alleged victim themselves. Sometimes it's from the defendant who thinks, you know what, the alleged victim, they don't want to show up. They don't want to be here. So what if they don't show up at the preliminary hearing? Does it mean that the case will be dismissed? No, it does not. And actually, remember, this is a list of the worst things that can happen to you at the preliminary hearing, and this can often be one of the worst. So the preliminary hearing is really the only chance that your attorney, the defense attorney, has to question the alleged victim, especially if they're not on your side. If they are on your side, okay, maybe it would be better if they didn't show up, sure. But especially if they are not on your side, if they don't show up, we don't get to cross-examine them. And no, it does not mean that the case will be dismissed. What it does mean is that, at least in the state of California, a police officer can testify as to what was in the police report. That's probably missing a lot of information, that may have misinformation compared to what is actually on the body-worn video of the alleged victim. And that is because of Prop 115, which is also PC 872B, which basically allows police officers, when they've had a certain amount of training, to be able to just sit up there on the stand and be a living police report. Now, one good thing here, though, is that usually the prosecution doesn't really want to do that. They try not to do that, and they only do it if they have to, because they want to see the alleged victim testify too. They want to see how strong their case is, and they're typically not in contact, at least not constantly or closely, with the alleged victim. So they would prefer for them to go up there on the stand, and then if they're terrible, that can potentially make your case better. So they do typically try to subpoena the victim. If the alleged victim doesn't show up, then we know, okay, maybe they're not going to show up for trial either. And depending on what other evidence actually exists as to there being domestic violence at all, the case potentially could be dismissed if the prosecution doesn't have really any other evidence or not good enough, and they don't have the alleged victim for trial. But for the preliminary hearing, if the alleged victim isn't on your side, if I, as an attorney, know that you are going to want to go to trial, if the prosecution doesn't give us what we want, or if they don't dismiss it, then I want the alleged victim to be there, because it is my only chance to ask hard questions of them, especially if the police just sort of took their story at face value and didn't ask those hard questions. I want to ask them to lock them into their story, so if they change it at trial, I can show that they have been inconsistent. And potentially they have told their story now multiple times and have had serious inconsistencies. And it's also a chance, though, for me to sort of evaluate the case, evaluate how good is the alleged victim on the witness stand, right? If they are not strong as a witness, then I can tell you that, and I can evaluate the case better. But it's a little bit harder if we don't get to see them testify at all. And it's definitely harder if we haven't locked them into their story under oath, right? If I can get them on the stand and get them to say, okay, I remember everything, here's what happened, and it's inconsistent, that is the key to winning a domestic violence trial. I hope you found this video helpful. If you do need help with your case, feel free to give me a call. You can find my number down below. You can also book a call with me there. And if you have a restraining order case, make sure you get your free first class in my course, Defeat the DVRO, via the link down below. If you did find this helpful, please make sure to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.